Good morning, Chair. Chair, today we'll be hearing evidence from Sir Rob Behrens, the former Parliamentary and Health Service Ombudsman. I'll be asking Sir Rob about the PHSO report entitled Missed Opportunities. It found that there had been a series of significant failings in the care and treatment of two vulnerable young men who died shortly after being admitted to NEP. The report considered the death in 2008 of a person referred to as Mr. R, and the death in November 2012 of Matthew Leahy. It identified multiple failings surrounding both deaths. The report also identified systemic issues at the Trust, including a failure over many years to develop the learning culture necessary to prevent similar mistakes from being repeated. Chair, we won't be looking in particular detail at the deaths of Mr. R and Matthew Leahy, but we will be looking at what missed opportunities the report says about both, and it's troubling. So Rob will also provide figures for complaints received relating to mental health and specifically in relation to the Essex Trusts. And later today, you'll hear from my colleague, Dr. Tabo Ilozue, and he'll be providing an overview of evidence received on the mental health services provided to Essex patients. Whilst he won't be referring to specific deaths, he will provide the picture over the period covered by the inquiry of local wards and services. So today's evidence may be distressing and difficult to listen to. And for some, it may not be possible to sit through the session. I'd like to make it clear again that anyone in this room is welcome to leave at any point. And again, I'd like to remind everyone that emotional support is available for all those who require it. The well-being of those participating in this inquiry is extremely important to the inquiry. We have, again, support staff from Hestia, an experienced provider of emotional support, here today, and for each day of this hearing. And there's a private room downstairs where you can talk to them if you require emotional support at all throughout this hearing. The Hestia support staff are wearing orange-coloured scarves and lanyards, and I know there's at least one in the room today. Would you just mind raising your hand? Thank you. Or if you want to, you can speak to a member of the inquiry team, and we can put you in touch with the Hestia support staff, and we're wearing purple lanyards. If you're watching online, information about available emotional support can be found on the Lampard Inquiry website at lampardinquiry.org.uk and under the support tab near the top right-hand corner. Chair, we want all those engaging with the inquiry to feel safe and supported. And so, Chair, we move now, please, to the evidence of Sir Rob Behrens. I'm going to ask that he come and take his place at the table.
Good morning.
I ask that you place your hand or hold the text and read what provided.
I, Rob Behrens, swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Sir Rob, have you provided the inquiry with two statements, one dated the 21st of March and one dated the 1st of April of this year?
That's correct.
And can you confirm that the contents of both are true and accurate?
I confirm that.
Do you have your statements in front of you?
I do.
You're welcome to refer to them if you need to. Your statements and the evidence that you provided by way of exhibits stand as your evidence, and I'll not be asking you about everything in your witness statement or all of the exhibits as a result. Can I just make sure that you are comfortably installed? There are, to your left, 2 big binders with documents in them. We can remove those if you need more room.
I can move them. Thank you. Can I just check about the sound? Is it possible to turn it up a little bit?
I'll speak a little bit more loudly, but I think we're arranging for the volume to be increased. Please, at any time, if you're having difficulty in hearing what I say, just let me know.
Sure.
So, Rob, were you Parliamentary and Health Services Ombudsman, or PHSO, between April 2017 and March 2024?
I was.
And does that mean that you've actually been out of the role for a little over a year?
That's correct.
And did Rebecca Hilsenrath, KC, take over from you in that role?
She became the acting ombudsman for a year from the end of March 2024.
In what capacity are you giving your evidence today?
I'm giving it in an entirely personal capacity, though I have had help from the office in obtaining relevant papers.
And I think you've provided some statistics and information that we'll come on to look at later.
Yes.
We're at an introductory stage of this inquiry, and part of that introduction is to look at matters of concern that gave rise to this inquiry.
Yes.
And that includes concerns raised by your work. The intention at this stage of our hearings is not to consider in detail any of the tragic deaths that fall within the scope of the inquiry, but I will be asking you about your report, Missed Opportunities, which, as we've just heard, addresses significant failures in relation to Matthew Leahy and the person you refer to as Mr. R. Can we start, though, by looking at the PHSO role?
Yeah.
Can you give a brief outline of what that role entails?
So there are 150 national ombudsman schemes throughout the world. The UK was in the second strand of national ombuds institutions created, and the parliamentary element was created in 1967, and a bit later the health element was created, and the 2 offices which operate under separate legislation have been joined together in one post, which is known as the Parliamentary and Health Service Ombudsman.
And so we're interested in the Health Service Commissioner for England role, and is the relevant law there the Health Service Commissioners Act of 1993?
Well, there are 2 acts. The Act of 1993 was amended, this is very significant for this inquiry, in 1996 to enable the Ombudsman to look at clinical issues which a number of my counterparts in other countries can't look at. And this gives enormous opportunity to look at the clinical failures in cases which are looked at with the help of independent clinical advisors who brief our case handlers.
Thank you. And what is the PHSO's relationship with government and the NHS?
The Ombudsman is a Crown appointment. The Ombudsman is appointed by fair and open competition. The candidate is then selected and has to be approved by the Prime Minister. There is then a parliamentary hearing, pre-appointment hearing, and if that goes satisfactorily, Parliament votes on the Ombudsman and the Crown then makes the appointment. So the key issue is that the Ombudsman does not report to ministers. The Ombudsman is independent of both the government and the National Health Service, and is there as an independent and impartial voice to look at complaints by users of the National Health Service.
Is the PHSO governed by a board?
Yes. Not a statutory board, but because the principle on which the Ombudsman was founded is the principle of corporation sole. Now, this gives all responsibility for every decision made to the Ombudsman alone in giving an account to Parliament. That is a constitutional fiction, and it's been recognised as such, so that the powers that notionally lie with the Ombudsman have been, with consent, devolved to a chief executive who carries financial responsibility and a unitary board which is appointed again by fair and open competition, which brings in non-executive members, and the board advises the Ombudsman about strategic direction, but has no responsibility whatsoever for individual case handling.
Is the board therefore made up of both executive and non-executive?
Yes, it is.
Who chairs the board?
The Ombudsman. And just for the record, when it comes to a review of what the Ombudsman has done, the Ombudsman steps down and the senior non-executive takes over the chair role to ensure there's proper accountability.
How are board members appointed?
By an open competition. But it's a competition run by headhunters under the jurisdiction of the Ombudsman, not by the Cabinet Office or another department.
You've said that the board scrutinises overall performance but not individual cases.
Yes.
How does the board exercise the function of scrutinising overall performance?
Well, there are regular meetings. There is a requirement that all aspects of the key performance indicators of the office are put before the board. There is extensive scrutiny. So the board has subcommittees. It has a finance and audit committee on which sits the National Audit Office to scrutinise the financial and accounting performance of the Ombudsman. There's a nominations committee to look at appointments. There's a people and welfare committee, and all of this is used to make sure that the Ombudsman gives a proper account before appearing before Parliament to give an annual account of what the office has done. So each year, the Ombudsman appears before the Public Administration and Constitutional Affairs Committee of the House of Commons in a challenging series of engagements to make sure that there is proper accountability.
Is there a subcommittee that looks at risk?
That's part of the audit committee, yes.
Why does the board not scrutinise any individual cases, and who does that responsibility fall to, apart from individual caseworkers?
Yeah, that's a good question, and the answer is that the Ombudsman carries the constitutional responsibility of making decisions about cases. And in that responsibility, there are mechanisms to make sure that the process is rigorous through the delegation, which we can come on to have a look at. But there's also an expert advisory panel which consisted of experts in the field like Dr. Bill Kirkup and James Titcombe, people well known in the health service field, to advise on how issues are addressed. But there is a strong feeling, or at least I have a strong feeling, that accountability for decisions should lie with the Ombudsman, not with the board.
Are you saying that there would never be a situation in which a single investigation might be discussed at the board?
I'm saying that.
They
would be aware that decisions have been made, and when I was the Ombudsman, there was a very, very serious case involving eating disorders, which is a form of mental health issue, that lasted for over 5 years. And at the end of it, I was so concerned about the implications of the case that I went to the board and said that I want to set up a review of how we handle that case, and we asked the expert advisory panel to run it, and the board were in agreement with that. So they were informed, but they didn't have responsibility for making a decision.
Thank you. Can we move now to...
Sorry,
yes.
This is very important. When I became the Ombudsman, my predecessor had set up a system in which she was able to commission people from outside the office on very difficult cases to make a judgment to see whether or not we, the Ombudsman, had got it right or not. In my view, that was not an appropriate mechanism, because it meant that the Ombudsman was not the decision maker of last resort. And I think that is a very important principle to uphold.
Moving to the remit of the PHSO, does the PHSO jurisdiction extend across England?
Yes, but wider than that.
And what is the extent of the jurisdiction?
So there are a number of elements to this. First of all, in England, the Ombudsman has responsibility for all matters complained about the National Health Service. But in addition to that, the Ombudsman retains responsibility for all aspects of non-devolved issues that are addressed by the UK Parliament. So issues that are not devolved, like home affairs, foreign affairs, social security, are also the responsibility of the Ombudsman, and that includes issues outside of England as well.
Thank you. I'm going to ask now that a part of your statement is put up on our screens. Please put up core bundle, page 207. And could you expand paragraphs 5 to 7? Thank you very much. This, Sir Rob, is where you provide a little bit more information about the PHSO. And I'd like to look at paragraphs 5 and 7. You say at paragraph 5 that the service is free for everyone, and it investigates complaints where someone or a group believes there's been injustice or hardship because an organisation in jurisdiction, and you then provide the relevant piece of law about that, has not acted properly or fairly, or has given a poor service and has failed to put things right.
Yeah.
And then at paragraph 7, you say, as health ombudsman, the PHSO can look at administrative issues of maladministration and has the power to make judgments about clinical advice and acts of the clinicians who are complained about.
Yeah. So, first of all, it's very important that unlike courts, anyone who comes to the Ombudsman has a free service. They're not charged in any way. And that is a very significant point of access for individuals. The second point is that the remit of the Ombudsman is about maladministration, which is mentioned in the legislation, but is not defined in the legislation, which gives responsibility to the Ombudsman to interpret it in a way which people understand that what they can make complaints about. So originally, in 1967, there was something called the Crossman Catalogue, which defined in non-legislative terms bias, neglect, delay, and so on as being part of maladministration. But as the office has developed and expanded, it has come to be able to look at serious service failure, avoidable death, as being aspects of maladministration. Now, this is very important because one of the things that government departments don't always understand is that maladministration is not the same thing as illegality. Things can be maladministrative and not be illegal. So there are whole aspects of service failure, for example, in the health service, which are unacceptable, but they're not illegal in that sense, and therefore the jurisdiction of the Ombudsman is different to a court or a tribunal.
Thank you. But can we just break down a little bit what you've put in those paragraphs? So we're looking at complaints about injustice or hardship, as we can see, arising from a failure in a service provided by an organisation that comes within your jurisdiction. We'll have a look at what those might be in a moment. And you say at the end of paragraph 5, and the relevant organisation has failed to put things right.
Yeah.
So if an organisation has acted, in your view, to put things right, you wouldn't have jurisdiction to take on the complaint.
Well, there are a number of aspects to this to be helpful. First of all, the person complaining has to be directly affected by what has happened. So under the law, good citizenship is not enough to be able to make a complaint, and I think that is very important. You have to demonstrate that you are affected personally or in a group by what has happened. Secondly, we will look at poor service. If something is clearly poor service but has been addressed and in the terminology put right, then that's not an issue that we would necessarily take forward, because we believe that the complainant has had the service that ultimately they deserve, as far as that's concerned. And thirdly, there is a defined list in legislation of bodies in jurisdiction.
And we'll look in a moment at a summary of that. But can I ask you about one other aspect of this? You refer, we can see in paragraph 5, to relevant organisations which have not acted properly or fairly. That's the language used there. And as you've already said, we've also seen the use of the word maladministration. Can you explain what is the difference, if any, between those two concepts?
No, well, because there is no legal definition, not acted properly or fairly is a way of describing in common parlance what maladministration means.
Thank you.
I mean, the big problems for the Ombudsman are, first of all, that very few people understand what the term means. And secondly, if you think that's bad, then ask people to define what is maladministration. And that's not a term that is used in schools today, I can assure you of that. So the organisation has a responsibility to communicate in simple terms what it can do and what it can't do.
Let's look at some of the organisations that are within your jurisdiction.
Yeah.
Please put up the exhibits bundle, page 535. And could you highlight or expand from for a complaint to be in remit? Next page. Thank you very much. So can we see here, this is a summary that you've provided of a much longer document that sets out the procedures of the PHSO. And here you summarise, or the relevant document summarises, the particular organisations that are in scope. We can see for a complaint to be in remit, we need to assess two aspects of the case: whether the organisation is in remit and whether the action being complained about is in remit.
Yes.
You then talk about, or the document then talks about, the relevant legislation and the fact that that sets out which organisations can be investigated. And do we see there, we can investigate, namely health service organisations, family health providers, and independent providers. And health service organisations broadly include, and does the document then set out in a number of bullet points which organisations those are? And can we see that the first one is NHS trusts and foundation trusts, and the last of the three bullet points is NHS England, clinical commissioning groups, and integrated care systems. And can we see at the bottom of the screen that independent providers may be in scope? Any person or organisation that provides a service of any kind, I think that should be by arrangement with a health service organisation or a family provider. So, having seen this, is a complaint about a mental health trust likely to come within the PHSO's jurisdiction?
Yes. But I need to be quite careful in responding to this. First of all, the Ombudsman cannot look at issues brought by staff against the Trust or staff who have complaints about each other. That is outside the remit. Secondly, as we may come on to, it has to be in time.
We will come on to that.
Thirdly, there are a number of other bodies that have responsibility for mental health complaints.
And we'll come on to those as well.
I mean, that is very, very important. And my other point would be that in comparison to other Ombudsman services, the Ombudsman cannot look at independent provision of health services or mental health services unless that is being funded by the NHS. Now, this is in direct contrast to the local government and social care Ombudsman, which can look at all private providers of social care. And frankly, I think this is an unnecessary restriction on the role of the Ombudsman. And my counterparts in other countries had the possibility of looking at independent health provision in the way that PHSO can't do.
Well, that actually takes us quite neatly to other limitations or restrictions on the PHSO role. Further to the one that you've just mentioned, what, in your view, are the main limitations on the PHSO's powers?
So first of all, the Ombudsman has the power of the High Court to call for papers. So there's no problem about securing information that might be difficult to obtain. And I think that needs to be put on the record. But the Ombudsman is operating unlike the vast majority of its European counterparts in being constrained to look only at those issues that are complained about by citizens and non-citizens. And I cannot emphasize enough how important this has been, particularly in the case of Essex, in limiting the Ombudsman's capacity to contribute to greater awareness and a public service in this issue.
Could you just expand on that? Why would the fact that you can only act on a complaint limit what you could do with relation to the issues that were arising in Essex?
Because there were a small number of very significant and heartbreaking cases in Essex where the families of the people who died were brave enough to complain about what had happened, and that was the focus of our investigations. But we subsequently discovered that in the same institution there were a significant number of other deaths where, for understandable reasons, because of bereavement or trauma or both, the families had not complained about, and the Ombudsman had no opportunity to investigate those cases. We'll come on to it, but if we had had the power of own initiative, then the resolution of these tragic issues could have been speeded up very dramatically, and I think that needs to be put on the record.
What does it mean to be a point of last resort?
So what it means is that constitutionally, under the law, users of the service have to try to resolve their issue by going to the frontline deliverer before they can come to the Ombudsman. And in the case of the parliamentary remit, they then have to go to their MP. But in the case of the health service, that doesn't apply. But it means that the Ombudsman would look at issues, does look at issues only after there's been an attempt at resolution, and the complainant does not believe they've received satisfaction from the outcome.
What if there is the possibility of a legal case to be brought by a putative complainant against a trust, for example?
Absolutely. So there is, in law, the provision that the Ombudsman would not look at a case where there is an alternative legal remedy. And the Ombudsman has discretion to look at those cases to advise the complainant that they would be better off going to law rather than coming to the Ombudsman. The example I can give you is in the close relationship we had with NHS Resolution, which deals with avoidable death and giving financial compensation. And we advised many families that if they were looking for a significant redress in financial terms, then they would be better off going to NHS Resolution than going through the Ombudsman process.
So we're going to hear about a number of bodies and regulators operating within the health and the mental health sphere. Is there a hierarchy as between them and the PHSO as to who should take on a particular complaint?
There's no hierarchy. It's colleagues seeking to do the best that they can in an overcrowded and horribly complicated situation.
Well, we'll come on to talk about the complexity of it in a moment. Is there a time limit within which a person needs to bring a complaint?
Yes. Again, the Ombudsman has discretion about whether or not to impose the time limit, but generally speaking, complainants have to come to the Ombudsman within 1 year of being aware of the facts which cause the complaint to be raised. Now, sometimes the attempt at resolution on the front line will take longer than a year, sadly, and in that situation, the Ombudsman will use their discretion to allow a complaint to be taken forward. But there has been litigation in a judicial review where the courts have opined that the Ombudsman took too long, allowed too long for that principle to be applied, and that there should be a more realistic interpretation of the rule.
Thank you.
And sorry, just before we go on, the Ombudsman is the last resort, but it doesn't mean to say that people cannot challenge the decisions of the Ombudsman, which they can do through judicial review. And there have been a small number of significant challenges to the decisions of the Ombudsman, which have led to useful improvements in the service. So it's not an absolute last resort.
Is there any particular form in which a complaint must be made?
Yes, and this is a reflection. I personally have been arguing for Ombudsman reform for a very long time. The system is out of time, as one of my Scottish counterparts described it, and in law, people have to make a complaint in writing. Now, in modern parlance, that is outdated, and that is a disincentive to some people to use the system. So,
could you just expand on what you've just said? A disincentive. Are there particular communities or type of people for whom providing a complaint in writing would be particularly difficult?
Absolutely. So, people with mental health challenges, elderly people, refugees, marginalised and vulnerable communities, they're not necessarily of a view that a written complaint is going to be the way that they get quick access to an institution. Now, we do what we can to assist there, but it is a hurdle that people have to go through.
So you were talking about things that you changed to make the PHSO a more effective operation. Would you change the way in which complaints can be submitted?
Well, as I said, first of all, the MP filter is iniquitous, and it's a disgrace which should be removed in legislation. That relates
to the other half of your role, if I understand things correctly.
I need to say that. The problem for the user is that they don't know where to complain because of the curious jurisdictions that make up public service ombudsman possibilities.
So we're going to come on to that, and we'll deal with that in a little detail. My question was actually about the way in which a complaint can be submitted, because as we've just seen, it needs to be submitted in writing. Is that a restriction that you would want to see removed?
Yeah, it is, but if you look at the evidence which we've given, the office receives around 125,000, 130,000 inquiries each year, which are predominantly on the telephone. They're not written down. So the office is already listening to people ear to ear or face to face without stuff going in writing, and I think that that's the way it should be, and that I wouldn't want to change.
And you've already spoken about the need to be able to proceed on your own initiative,
Yeah.
or your own motion, and not have to rely on a complaint being made.
I mean, I did a big study for the International Ombudsman Institute on ombudsman services coming out of COVID in 2021. All my European counterparts had the power of own initiative. In the new ombudsman schemes in the United Kingdom, in Northern Ireland and in Wales, there are powers of own initiative. And it's absolutely astounding that the Ombudsman doesn't have that power as a UK Ombudsman. And it is a serious limitation on our capacity to serve the public.
Amanda, would you take down the document on the screen? And I want to now move to the point that you've touched on already, which is the complaints landscape, if I can put it in that way.
Yeah.
We have had the benefit of a presentation and slides accompanying it from given by the King's Fund. What I want to do, just to introduce this topic, please, is to look at one of the slides provided by the King's Fund. Would you put up, please, King's Fund slide 23? So here we can see non-NHS regulatory and investigatory bodies. And can we see in the left-hand column the healthcare regulatory bodies, such as the General Medical Council, the Nursing and Midwifery Council, and the Health and Care Professions Council? And do we also see in further columns the HSE, or the Health and Safety Executive, and then your organisation, as well as the Coroner's Service? So those are all bodies or organisations operating within the health and also, to a certain extent, the mental health sphere. Is that correct?
It is correct, but it's incomplete.
Well, hold on just for one moment, because we'll come and look at another slide in a moment. Could you put up the King's Fund slide 22, please? So this is NHS regulatory and investigatory bodies. And can we see here further organisations throughout the years, including the Mental Health Act Commission, the Care Quality Commission, NHS England, and the Health Services Safety Investigations Body, or HSIB. So are these, again, further organisations that we need to be aware of in this area?
Yes, and some of it is also missing here. So we not only have the absence of the local government and social care ombudsman. One of the big defects of the system is that health and social care are not integrated in an ombudsman service. So people don't know where to complain as far as that is concerned. Secondly, we now have a patient safety commissioner, which is not mentioned here, who has the own initiative to look at patient safety issues, and she does a brilliant job in doing that. And we have HSIB, which under it looks at serious issues of safety, but unfortunately it has taken away the power of the Ombudsman to look at serious issues without the permission of the High Court. And I took that case to the Venice Commission in the Council of Europe, who agreed with me that this was a wrong restriction on the role of the Ombudsman, but the government took no notice of that.
Could you take down that slide, please?
think I'd just like to say, asking members of the public to appreciate those two slides, which are simplified and wrong, is a big part of the problem.
Well, we'll look at it a little bit more, because in your second witness statement, you make the point that there are more than a dozen different health and care regulators playing important roles in patient safety.
Yeah.
And that's something that you've raised in one of the PHSA reports called Broken Trust. Is Broken Trust a report from 2023 with the full name Broken Trust, Making Patient Safety More Than Just a Promise?
Yeah.
And did that report consider reasons for continued failures to accept mistakes and take accountability for turning learning into action and improvement?
I mean, everything that we said in Broken Trust applies today. We argued very strongly that the regulatory framework was overcomplicated and needed to be reformed.
Can I ask you to pause there, because I actually want to look at the relevant part of the report where you say that.
Okay.
Could you put up exhibits bundle page 450, please? Can we see here part of the report? I just want to look at what it says here. Second, political leaders have created a confusing landscape of organisations, often in knee-jerk reaction to patient safety crisis points. Now, is that referring to what you've just been talking about? Yeah. HSIB, the Patient Safety Commissioner, PHSO, NHS England, NHS Resolution, and more than a dozen different health and care regulators all play important roles in patient safety. But there are significant overlaps in functions which create uncertainty about who is responsible for what. This means patient safety voice and leadership are fractured. This is not due to a lack of dedication and professionalism from those tasked with championing patient safety. The problem is structural, and the report goes on to say that the government must consider the case for streamlining some of these functions for the benefit of people who use the NHS, their families and carers. This is not about reducing investment in patient safety. It's about creating a system that is coherent and easier to navigate based on evidence and engagement with patients, families, NHS staff and leaders. So the report refers to a confusing landscape of organisations. May I ask you some questions about that? In your view, does the confusion extend to which of the various bodies has jurisdiction to consider a matter of concern?
Yes. So, to illustrate, in the field of mental health, there are four possibilities of complaining. CQC has some responsibility, the Local Government and Social Care Ombudsman has responsibility, and a Mental Health Act Tribunal also has responsibility, in addition to PHSO. So you need to be very clever to understand where to complain about.
Does this overlap, for example, in the bodies that you've just referred to, create a general uncertainty about who is responsible for what?
Yes. I mean, you have to be pragmatic as ombudsman, and one of the things that we did was to work with the Local Government and Social Care Ombudsman to create a joint working team in which the two organisations bring together investigators to look at complaints where there is overlap between the two services.
And in fact, I'm going to come on to ask you about wider cooperation in a moment. Just sticking with the complexity point, if I may.
Sorry, could I
Yes,
just,
of course.
you mentioned 4 organisations in respect of a mental health complaint that might have a part to play. What about other people you've identified also, like the HSIB arrangements and the Patient Safety Commissioner? Presumably they too would be
But they don't look at individual complaints.
I see. You were referring specifically to
Yeah.
complaints. I'm so sorry. Thank you.
I have great respect for HSIP and what they do. My problem with them is that by excluding the Ombudsman from looking at their investigations, they have reduced our power to intervene in a way which is not helpful. Although that has not been tested with a particular case at the moment.
Thank you.
Just dealing with the complexity point, is it possible in your view that some incidents fall through the gaps between the various bodies and are therefore not investigated when they should be?
I think that is the case. I think there are a lot of people who simply don't know where to go. I think there is a problem which we also raised in the Broken Trust report, as you will know, saying that advocacy services, which advise people about what to do and where to go, have been on the decline because of a lack of public funding. And that was one of our recommendations, that for people to be properly informed about how to go about making a complaint, they very often need advocacy services, and they've been scarcer.
Given the complexity again, what certainty do we have now that deaths in the mental health context are always properly being investigated?
I think what the Broken Trust report showed was that in a large, more than nearly 24 cases where the trust had said there was no issue here, we as the Ombudsman had looked at the case and found cases of serious failure and avoidable death. And that is very worrying. And I think coroners have come to the same conclusion on the issue of eating disorders, that trusts have been reluctant to look at issues that they should be looking at. So I have no great confidence that the system is right at the moment.
We've looked at various bodies, including the CQC.
Yeah.
Is there anything in particular arising from the remit of that organisation that causes difficulties?
Well, first of all, the CQC has had serious internal problems in the last couple of years, which have been publicly reported, about its ability to carry out reviews. Which is a problem. It also applies to the Nursing and Midwifery Council. So the regulatory partners themselves are not in optimal condition. And where, for example, where there is bullying taking place in an organisation like NMC, can we rely on the NMC to call out bullying in the health service? I think that is a very important issue.
As we can see the extract that's still on our screen, you make, or the report made the case for streamlining some of the functions. What did you have in mind, or what, in your view, could be done to streamline?
I mean, unusually, when it comes to my personal record, the government actually listened to what we proposed in this report, and they established an inquiry by Penny Dash, which is currently, it's not reported yet, to look at this very issue, to see whether there could be a streamlining to make it more simple for users to understand the service and for there to be less overlap. For example, and this is my view, it's not the view of PHSO, we have a brilliant patient safety commissioner who operates as a singleton, Henrietta Hughes. She does a great job, and she did a brilliant job in ensuring that Martha's Rule would be implemented to allow people to get a second opinion when they're concerned about how their relatives are being treated. Should that be a standalone role when you have a separate ombudsman service, you have a separate HSIP, and you have a separate CQC? That's one example. Another example is that we're supposed to be joined up and working together, and largely that's what is done. But CQC is a body in jurisdiction for PHSO. So in addition to working together in the regulatory framework, PHSO has responsibility of oversight of what CQC does. And in a number of cases where I found maladministration in CQC over the fit and proper persons test in the health service, there was dismay in CQC that a regulatory partner would call them out in this way. So, it's not all roses and flowers.
Can we move to look at ways in which the different organisations that we've been looking at do cooperate? Could you take down the document from the screen, please? And I want to talk about the Health and Social Care Regulators Forum. This is paragraph 13 of your statement. Have you set out there the various bodies and organisations which are members of the forum? Yeah. And can we see that they are the CQC, the General Dental Council, the General Medical Council, the General Optical Council, the General Osteopathic Council, the General Pharmaceutical Council, the Health and Care Practitioners Council, the other Ombudsman, the Local Government and Social Care Ombudsman, NHS England and NHS Improvement, the Nursing and Midwifery Council, the Professional Standards Authority and Social Work England, correct?
Well, there are others as well. So the Patient Safety Commissioner is now a member of the forum, and HSIP is a member of the forum too.
What is the purpose of the forum?
To allow the regulators, so the Ombudsman is not a regulator, it has no regulatory power, it has no power to bind decisions which are made, which regulators will do, so it has no coercive role, but it is part of the regulatory framework, and it is sensible and appropriate that there should be a forum for people to come together to discuss issues of common concern, so that there is a general awareness about what's going on in the system. And it does perform that role, and I think that's good.
You say in your statement that NHS England used to sit on the forum, but does not do so anymore. Do you recall approximately when that happened and why?
No, I mean, NHS England is no more. So you'll have to ask them about that.
You also...
I think there is a problem about historically the role of NHS England being independent from, separate from government. And if you're going to have a regulatory forum, you need a degree of independence in order for that to have credibility. So I think that's one of the issues.
You also refer in your statement to an emerging concerns protocol.
Yeah.
What is that?
So this is the ability of one of the regulatory partners to say to the partners, this is an issue of such concern that we're dealing with that we feel it should be put in the public domain through the protocol. And I think that is a good thing. The problem is that it's hardly ever been used. And the only time that I'm aware that it's been used was by PHSO in dealing with the unacceptable behaviour of Universities Hospital Birmingham Trust and their reluctance to cooperate with the Ombudsman over a prolonged period of time. But we did it, and it had the appropriate effect of getting the Trust to finally take notice of what the Ombudsman had been saying. So it needs to be used more.
In fact, there has been a development, I think, since you have stopped being PHSO. Chair, may I just use this opportunity to refer to information provided by Rebecca Hilsenrath. And she explains in her first statement, the reference for anyone who wants is at Core Bundle, page 248, paragraph 5.2. She says, in late 2024, it was agreed to merge the Emerging Concerns Protocol group with the Health and Social Care Regulators Forum thematic group. And can we please put up Core Bundle, page 251? And could you expand paragraph 4 and 4.1, please? This is a second statement from Ms. Hilsenrath, and she's asked what was the reasoning behind merging the Emerging Concerns Protocol with Health and Social Care Regulators Forum thematic group, and her response we can see here. On a practical level, it's hoped that bringing together the two groups will reduce the potential for duplication of discussion and encourage proactive discussion on thematic issues of interest across members. By incorporating the ECP discussions into the forum, it is hoped that there will be more organic consideration of where a thematic interest area could generate an early indicator of a need to trigger the Emerging Concerns Protocol based on insight from other members. So Rob, is that an approach that you'd agree with?
I do agree with that. But I also need to say, in my experience of having been an ombudsman in legal services, in higher education, in health and in government, that I've never come across a regulatory area as complicated as the health service. And that without addressing the core issue of simplifying the number of regulators, 4.1 won't have as much effect as it needs to have.
Well, that is a question I was going to ask you. To what extent does the forum and your ability to talk to people outside the forum as you need to mitigate the extent to which the complexity has caused problems?
Well, you know, these are groups of public servants who do their very best under the circumstances which they're operating in. But the core issue is, does the public understand how the system is regulated and where they go if they want to make a complaint? Anything else is filigree. And at the moment, I have no confidence that people trust the system because they don't know where to go when they want to make a complaint.
Could you take down that document, please? Can we just take stock? So, as we've just been discussing, are there, if I've understood your evidence correctly, are there two general areas that you believe should be addressed? First of all, the limitations on the PHSO's powers that you've described, and secondly, the complexity of the complaints and regulatory landscape, including specifically in relation to mental health care.
Yes, could I just say this, that I'm not an aggrandizer for ombudsman power. I do understand that there are areas that you wouldn't want to go in. I have heard people argue for binding powers for the Ombudsman. So at the moment, as you know, the Ombudsman can't force anybody to do anything. Its recommendations are recommendations. And I know from watching the experience in South Africa recently, that where the Ombudsman does have binding powers, that has led to enormous litigation in the Constitutional Court and below, where people have challenged the power of the Ombudsman successfully, and in fact she was impeached as a result of these things. We don't want the Ombudsman to be judicialised. We don't want to make the Ombudsman a second-class legal service. It's not that. It's separate. And I would not support binding powers.
We're going to come on later to look at some statistics that you have provided. But with the limitations and the complexity that we've just been discussing, I want to look at caveats that we may need to apply to the statistics that we come on to.
Yeah.
Well, in brief, does it come to this? Because of the limitations of your role, and because there are a number of other organisations working in the complex landscape you described, do the statistics you're able to provide actually only provide part of the picture?
I think they do only provide part of the picture. Because we only can look at cases where people come to us. So if the wider issue of people having grievances and complaints about a system which they don't complain about is not available to us. And you may come onto it, but we did a survey with YouGov in which we asked 3,500 people for their experience of complaining in the health service.
Well, we will come on to look at that.
Okay, and what that showed, and I just make this point, is that many people with mental health challenges did not want to complain, and our data doesn't cover that.
So if this inquiry wants to build up an accurate picture, to the extent that that's possible, of what was occurring, we will need to go to the various other organisations and bodies to seek information from them too. Is that correct?
That's correct.
I want to deal now with procedure, please. You cover this in some detail in your statement, and I don't propose to do that now. But the procedure that you adopt, does the process you describe involve a number of different stages, from receiving the complaint and considering whether it's within the PHSO's jurisdiction, to primary investigation and consideration whether the complaint can be resolved quickly without further investigation, through to detailed investigation for complaints that can't be resolved at the primary investigation stage, and on to provisional views shared by the PHSO with the parties to allow them to comment on them, through to formal finding with the PHSO formally upholding or not upholding the complaint, or actually upholding it in part. And then, as you've just been discussing, recommendations, which we will come on to look at. You've told us that, in fact, you do have power to require or compel evidence. And just looking at formal findings briefly, in what form are formal findings delivered to the relevant people? Are they presented as part of a report, or is there some other way?
No, they're presented in the final report that the Ombudsman issues.
And who is the report sent to, generally?
It's sent to the complainant and to the body in jurisdiction, and subsequently, where it's appropriate, to the co-regulators. Because one of the issues for a non-regulator is oversight of the implementation of the recommendations which are made. And that's why it's so important for the Ombudsman and the CQC to work together. Because after a period of time, it's not appropriate for an Ombudsman to keep monitoring what a body in jurisdiction has done or not done. And it's up to other bodies to make sure that that is borne in mind.
Or we'll come on to aspects of that a little later on. Can we come on, though, to look at recommendations in a little bit more detail? As we've just seen,
before you do that, if
yes.
I can be helpful, the intake and the early resolution phase of what the Ombudsman does is absolutely vital in terms of making sure that citizens are listened to. And we have an early resolution team which has been set up to see whether or not it's possible, when complaints are received and seen to be appropriate, whether some resolution can be made without there being a formal investigation. And one of the things that I was able to do was to create a mediation team in the office to try and increase the number of complaints that are settled by talks between the complainant and the body in jurisdiction itself. And this is a very important development. It's not yet to scale, but it does mean that there's a possibility of avoiding a long, drawn-out investigation going through primary and then detailed investigation. It's something that needs to be have bigger capacity.
So if we look at statistics, which we may do, that show that not maybe quite a large proportion of complaints don't make it past primary investigation, from what you've said, that shouldn't necessarily indicate that something wrong has happened. It may, in part, indicate that there has been appropriate early resolution.
Yes, but to be fair, the vast majority of the reason for not taking cases further is that they're out of jurisdiction, so they're not appropriate for the Ombudsman to take them forward. And I think Sir Bernard Jenkins made this point when he was chair of PACAC, that one of the unacknowledged roles of PHSO is to be an advice centre for people about what to do when they have problems in the NHS, to guide people to different complaints bodies and regulators. And that is a very important role, which needs to be thought about as well.
So if someone gets in touch with the PHSO and a decision is made that their complaint is not in your jurisdiction, your team or the PHSO team might signpost them to another organisation.
Absolutely.
As I said, I'd like to just look at recommendations, please. Yeah. So where a complaint is upheld, the PHSO considers what recommendations to make, and will they be included in the report?
Yes.
What is the purpose of recommendations?
The purpose of recommendations is to make it useful for both the complainant and for the body in jurisdiction. So quite often, the thing that the complainant most wants at the end of a process is, first of all, an apology, and a proper apology, and some of the apologies that I've seen aren't worth the paper they're written on. But secondly, some element of financial redress for what has happened. And then thirdly, and this is very vital, people say to the Ombudsman, I'm complaining not for myself, but to make sure that the system learns from what has happened so that it doesn't happen to somebody else. And so we made operational and policy suggestions in our recommendations to try and make sure that what occurred doesn't occur again. And that is what is so frustrating about the Missed Opportunities report, that we made strategic suggestions, and they were taken no notice of.
So let's just be clear. In missed opportunities, you were looking at the case of Mr. R and Matthew Leahy.
Yeah.
In both of those cases, there was a final report at the end of the PHSO investigation,
Yeah.
and both of those reports included recommendations.
Yeah.
So the recommendations you've mentioned, I think, apologies, financial redress, and general recommendations for learning and improvement. You mention also in your statement that explanations can, a requirement or a request for an explanation can also be included as a recommendation.
Yeah.
Which type of recommendation is made most often?
Well, I think fundamentally apologies are the critical issue, but they tend to be associated with operational and policy recommendations to go with it, because if there's been a service failure, we want to make sure that doesn't happen again, so there are implications as far as that's concerned. The financial redress comes from the body in jurisdiction. It doesn't come from the Ombudsman. It's around £500,000 a year, which is very small in comparison to what NHS resolution pays or the Infected Blood Compensation Authority. But it is important in being tangible to people that their complaint is valued.
How often is financial redress recommended?
I think I have to check. I can't remember, but I think it's about 1,000 cases a year. There would be financial redress.
I know every case is different, but do you have a view about the principles of an apology that you consider ought to be evident in an apology?
Absolutely. And it starts from the bad practice of public bodies saying, if you were upset by what happened, then we're sorry. In other words, it's your fault that you were upset, and the apology is a put-off. It has to be genuine, it has to be sincere, it has to be empathetic. And we have, along with Social Care Ombudsman and other ombudsman schemes, set out the principles of what constitutes a good apology. One of the key players in this field is Chris Gill at the University of Glasgow, who's done research into this. So there's a big difference between different types of apology.
Do you?
Sometimes they can be very patronising, and it just shows a lack of empathy.
Do you ever recommend that a public inquiry should be instituted?
Yes, and that's a big issue. Can I take a glass of water before responding?
Please do.
So, this is very serious. There is legislation about public inquiries being commissioned, which applies. But in my view, it is used or has been used in a very cavalier, inaccessible way, meaning that it's arcane about how public inquiries are commissioned. And the two examples I can give of that are, first of all, the case of Robbie Powell, which you may be aware of, who was a young boy who died of Addison's disease in 1995. where there was evidence of a cover-up by the doctors who looked after him, and then of fraud by the police that investigated the case, and the evidence went to the Crown Prosecution Service. And Mr. Powell was promised by various politicians that there would be a public inquiry to look at this, and he has worked for 35 years to try and get that inquiry and has been unsuccessful. And I have supported in public, along with the Welsh Ombudsman, the need for a public inquiry to look at this disgraceful set of events which government has decided that they won't look at. So that is a concern. This issue, the Lampard Inquiry, which I'm really pleased to see coming about, has frankly taken far too long to come about because the government was extremely reluctant to create a public inquiry in these issues. And despite all the evidence to the contrary, it wouldn't have an independent inquiry after our report, Missing Opportunities. And then it went for an independent inquiry against the advice of many people, which, as you know, collapsed because clinicians would not participate with it. And I was promised by the Cabinet Office in 2020 that they were looking to review the rules for public inquiries. And that came to nothing. And we still have the same arcane, non-transparent approach to creating public inquiries. And there was, frankly, a disgraceful exchange between two health ministers about this issue involving Matthew Leahy's mother, in which they clearly showed no public service element in their consideration of whether there should be a public inquiry.
I think those were text messages or communications that we saw a little of at our hearing in September. Is your point, in short, that the current mechanism for setting up an inquiry, at least a statutory inquiry, which requires a minister to act, not the appropriate way forward? And twinned with that, are you saying that politicians too often call for public inquiries without actually following up?
I'm saying both those things.
That's what I understood. Thank you. Chair, it's time now for our mid-morning break. Could we come back at 1:45, please? So 15 minutes. Thank you very much.
15 minutes, thank you.
Can I ask someone to help Sir Rob with some water, please?
It's okay.
So Rob, we ended the last session talking about public inquiries. Is there anything further you'd like to say on that point before we move on to another topic?
Yes, thank you. There's just one final point I'd like to make. With due respect to you, one of the big problems about public inquiries is what happens after they've reported. And there, as Dr. Bill Kirkup has made the point, that time and again we have big public inquiries which make brilliant recommendations which are not implemented. And of course politicians have to make decisions, but it seems to me there needs to be a mechanism through perhaps the National Audit Office to monitor what happens to recommendations of public inquiries, so that the public get a chance to see the impact of these inquiries on policy development.
Thank you. In fact, sort of recommendations and implementation of recommendations is very much on the radar of this inquiry, and we've set up, as I mentioned last week, a recommendations and implementation forum to start looking at implementation even at this early stage of the inquiry. You have spoken about some external body that might oversee implementation of recommendations, and we'll be hearing next week from Deborah Coles of the organisation Inquest, and she, I know, and her organisation have views about that too, and they are in favour of something they refer to as a national oversight mechanism. Yeah. And so I'll ask her about that as well. But since we're dealing with implementation of recommendations, can we look at that topic in relation to PHSO recommendations? You've already told us that you don't have the power to require implementation, and indeed you don't want it, or you wouldn't personally advocate it. But how does PHSO monitor the implementation of recommendations once they're made and included in a report?
So when a report is issued, we give the body in jurisdiction usually 3 months to be able to come back and explain to the office how they've gone about implementing the recommendations. And broadly speaking, that is successful in the sense that in routine matters, trusts tend to accept the recommendations and to implement them. But that's not always the case, and the challenge for the regulatory framework is to make sure that even if an ombudsman has recommended something, beyond that 3 months, the regulatory partners make sure that it's not forgotten about.
Does that happen at the moment? Say, take a report containing various recommendations issued to a trust. Once the PHSO is satisfied that those recommendations have been implemented, do you then hand over to a relevant regulator to monitor things further?
Well, a couple of things. One is when when we make when we issue a report, in general, that is copied to the CQC to make sure they're aware of that. Secondly, in serious cases, we would lay the report before Parliament so that the Select Committee gets an opportunity to see whether or not the recommendations have been implemented. And I think, as we'll come on to, laying the missed opportunities report before Parliament and allowing the Select Committee, PACAC, or that body anyway.
So that's the Parliamentary and Constitutional Affairs Select Committee.
They conducted their own inquiry into the extent to which the recommendations which went beyond the trust to government in general, and they played a critical role in raising awareness about the recommendations and the issues. And unfortunately, after Sir Bernard Jenkins stood down as chair of PACAC, that ceased to happen, and I think that is a retrograde step. The Ombudsman is supposed to be an officer of Parliament. If select committees don't take up the reports of the Ombudsman, when there's been a failure to implement recommendations, that reduces the authority of the Ombudsman.
But the mechanism you've just discussed, elevating cases beyond the trusts and onwards and upwards up to Parliament, you can't do that in all of the cases of non-compliance, can you? I mean, there'll be many instances of non-compliance where you don't seek to elevate through an additional report or putting a matter before a select committee.
Yeah, that's true, and it's about proportionality. So, to give you one example, I can recall a deeply problematic dentist who had arbitrarily excluded a patient from their list and refused to accept our recommendation that the patient should be restored to the list, despite everything we did to try and make this happen. And on grounds of proportionality, we decided this was not something we needed to put to Parliament.
Can we just dig down into the actual way in which PHSO checks whether a recommendation has been implemented? Is it the caseworker who does that, or how does it work?
Yes, I mean, it's guided by the caseworker. One of the issues to consider is that we have tended to ask bodies in jurisdiction to provide a report on what they've done in response to the recommendations, rather than specifically mention issues that have to be addressed. Sometimes we'll ask for a change progress report. So that element is a bit subjective about whether or not it has been implemented or not.
But if you're recommending, for example, some kind of financial redress,
Absolutely. I mean,
written apology,
those things are very clear, and in general, bodies in jurisdiction are good at delivering on those things.
can I ask you this? Does the PHSO check whether the complainant agrees that a particular recommendation has been implemented?
Good question. I mean, we obviously talk to the complainant, and there will be correspondence with the complainant, but formally we don't go out of our way to ask the complainant if, or we didn't go out of our way to ask the complainant. Maybe that's something that could be done to improve the system.
How confident are you that the PHSO's monitoring really does identify where a recommendation has or has not been complied with?
I'm reasonably confident because of what I've seen over a 7-year period, because the power of transparency and publicity is all important in this area. And in my time, we did a great deal to publicise what had happened in individual cases with a whole new approach to putting summaries of cases online. And frankly, bodies in jurisdiction don't like adverse publicity. So it's not about moral suasion, as the old ombudsman writers used to say. It's the moral power of the ombudsman. It's about embarrassing the bodies in jurisdiction that really has the impact that is.
So this is something you've touched on before, but I want to look at it in a little bit more detail. We've heard from you that the named organisations are not obliged to carry out your recommendations.
Yeah.
What's the process where a caseworker or someone else within the PHSO finds that compliance has not been completed?
They will report it to their operations manager, and that will be addressed and it will come up to the Ombudsman if there's continued reluctance to comply.
And you've mentioned that ultimately there's a power to lay a report before Parliament.
Yeah,
And do we actually see that with the missed opportunities report that we're going to come on and look at?
absolutely.
What would you hope to achieve by laying a report before Parliament?
Exactly what the Missed Opportunities report did. The Select Committee summoned the government and the health service to give an account of what they had done in response to the very serious failures in these cases. And the government produced its own evidence, and it was deeply embarrassing for the government to have to go through this process, and necessary. We'd done our bit, we passed it on to the Select Committee, and they then did their bit.
Thank you. I'd like to move to a new topic now, please, and that is generally complaints to your office when you were in role, looking at matters at a general level, and then coming on to look at missed opportunities, the report. You've set out at paragraph 26 of your first statement statistics for the number and types of complaint received by the PHSO. Could you put up, please, core bundle page 211 and expand paragraph 26? So number and types of complaints received. I think you've mentioned this already. In a non-COVID year, the office would expect to receive over 100,000 inquiries from the public, mainly relating to health service issues. However, as you say there are a growing number of inquiries falling into the other side of your role. Could you please go to the next page, show the full page? And what you've done, don't worry, we don't need to look at these in any detail. Over a number of pages of your statement, you've provided statistics in relation to complaints. And just looking at this page, for example, can we see that on an annual basis from, in fact, it was 2011-12, you provide figures for the total complaints received, those that fell within PHSO jurisdiction, those identified as relating to mental health, and then those relating to the Essex trusts.
Yeah.
Please, could you go to the next page, just to give an idea of the amount of information that's been provided, and show the full page? And then the page after that. And then can you go to the page, can we just see at the bottom 2023, 2024 of the year that the data relates to there? And would you go to the top of the next page, please? And just expand those top bullet points, please. So can we see that over those pages, you've provided, helpfully, information from the 2011-12 year right up to the year we've just looked at, covering those various areas that I was just mentioning. Thank you. Could you take that down, please? Now, so Rob, the inquiry legal team has converted the statistics we've just scrolled through there and turned them into a chart. Have you been provided in advance with the chart, and have you had time to consider and check it?
I have, thank you.
Are you happy that it, and in fact we'll look at one more, adequately plots the statistics we've just seen?
Yes.
Thank you. Amanda, would you put up chart 1, please? So here we can see the statistics going back to the 2011-12 period and up to the 2023-24 period, can't we? And this is relating to health-related complaints, both physical and mental, covering that period. I think it's right that, or at least the inquiry has been told by your office, that for various reasons you're unable to provide data before 2011-2012. So can we see that this chart plots the total number of complaints relating to physical health received year by year, together with the numbers relating to mental health. So the physical health is the blue part of the bar, and the complaints relating to mental health is the, I'd say that's pink part of the bar. So first point, these are national statistics, aren't they? They don't relate to one part of the country or Essex. Do you have any observation about the proportion of complaints relating to mental health as opposed to physical health that PHSO receives?
Yes. I think you can see from the chart that excepting the COVID year, when we had to close down our operations because of the crisis in trusts and NHS bodies, there's been a slow but significant rise in health complaints, but not necessarily in mental health complaints. And this really synergizes with the study which we did of service users of mental health.
We'll come on to look at that in a moment.
Okay.
But is there any particular reason, in your view, why the proportion of mental health complaints appears to be small compared to that relating to physical health?
Yes, because people with mental health challenges are often in a less advantageous position than other people to make complaints. A, they're not necessarily able to make complaints themselves. B, they may be in a very tricky, confined situation which makes making a complaint difficult. And C, what we know is that very often, and this is also true with elderly people in the health service, that there are two dispositions which don't apply to other sectors of the community. One is that they don't want to bother the system, and two, they feel that they might be victimised if they did make a complaint.
Well, that does take us, doesn't it, to your survey. So can we put up, please, exhibits bundle page 152? So you've mentioned this a couple of times, I think, Sir Rob. Is this a survey of experiences of NHS mental health care in England conducted in February 2020, or at least reporting in February 2020? Can we see there that, thank you very much, that the survey asked people about their experiences of using NHS mental health services in England, and it included an open question that allowed participants to give more detail about their experiences. Now, Sir Rob, you've referred to, I think, these responses, is that correct?
Yes.
So the key findings were 1 in 5 people did not feel safe while in the care of the NHS mental health service that treated them. Over half, 56%, said they experienced delays to their treatment, and 4 in 10, or 42%, said they waited too long to be diagnosed. Also, almost half, 48%, said they'd be unlikely to complain if they were unhappy with the service provided. And 1 in 3, or 32%, said they did not think their complaint would be taken seriously. And I think, touching on something you've just mentioned, the main reason given for not complaining was that they would not want to cause trouble. So does that pick up on the points that you wanted to?
Absolutely.
Is there anything further arising from those bullet points that you'd like to tell us about?
Well, I think this wasn't just any old survey. It was YouGov that did it for us. So the figures are statistically reliable. They're not just impressions.
Thank you. I'm going to ask, can we go to the next page, please? And in fact, what you do in the survey is to summarise key findings in another report, Maintaining Momentum. Is the full title of that report, Maintaining Momentum, Driving Improvements in Mental Health Care, and was it produced in 2018?
Yes.
And do we see here, summarised conveniently, 5 themes arising from that report?
Yes. And I think, if I may say so, that point 3 is a very significant point.
Well, let me read them out, and then by all means make any
Sure.
observations that you want. So the 5 failings are identified in Maintaining Momentum are listed as, first of all, failure to diagnose and or treat the patient. Secondly, poor risk assessment and safety practices. Third, not treating patients with dignity and or infringing human rights. 4, poor communication with the patient and or their family or carers. And 5, inappropriate hospital discharge and aftercare of the patient. You wanted to speak about one of those. To give us any observations you wish arising from those 5 key points.
Sure. I mean, they are all fundamental to the issues around safe care in the NHS. Point 4, poor communication. We come across that time and time again across the whole of the health service. The poor communication, often the lack of respect that service users receive, and their families too. But on number 3, and mental health, the Ombudsman has no power in law to look at human rights issues. And I gave evidence before I ended my term to the Justice Select Committee in the House of Commons, who were looking at whether or not they should create a new human rights ombudsman in the UK. And I said that that was a nonsense to do that, because what you needed to do was to incorporate, you don't need to further create more ombudsman schemes when we've got too many already. So it would be appropriate to give a human rights mandate to the existing ombudsman. There are 2 cases in that report where the human rights of mental health patients were flagrantly violated. One was in the case of a woman who was menstruating but had no opportunity to address that issue because everything was taken away from her. And the other was a case of a woman who had given birth to a baby. She had mental health challenges. The baby was taken away from her without any consultation or consideration of the impact for the person. That is a fundamental human rights issue. We looked at it. It's just that we couldn't say that it was a breach of human rights in law.
Maintaining Momentum was published in 2018. Are you able to say to what extent these 5 failings remained of concern up until the end of your period as Ombudsman?
I think what's interesting is that in each of the reports that we have published, going on to the Broken Trust report and then the Discharge report, these issues don't go away. They're there time and time again. We keep talking about poor communication, the defensiveness of institutions. I don't think these are fundamentally addressed as far as things go that I could see to the end of my term.
So you've referred to 2 reports there, Broken Trust Making Patient Safety More Than Just a Promise, which was published in June 2023,
Yeah.
and Discharge from Mental Health Care, Making It Safe and Patient-Centred, which was published in February 2024, so close to the end of your period as Ombudsman.
Yeah.
And these are issues you say that we see recurring.
Well, if you look at what we reported in Broken Trust, it was about the failure to make right diagnosis in too many cases, delays in providing treatment, poor handovers by clinicians, and a failure to listen to the concerns of patients or their families. You know, that is pretty much the same as we were saying 5 years earlier.
Thank you. Would you take down the document on the screen, please, and would you put up chart 2, please? So this chart relates to the same data we looked at before from paragraph 26 of your first statement. So do we see here mental health related complaints over the period that we've been looking at? And this chart plots mental health complaints on a national but also on an Essex basis. Can we start by looking at the national statistics, the darker blue bars? Can we see in this chart that in the period 2011-12, a total of 1,769 mental health related complaints were received nationally? And that by the end of the period covered, 23-24, that figure had risen to 2,558, albeit with fluctuations along the way.
Yeah.
Just your successor, Rebecca Hilsenrath, refers to a spike between 2018-19 and 19-20, and she attributes that to the impact of the COVID pandemic. Would you agree with that?
Yes, I think COVID had a more adverse impact on people with mental health challenges than other health cases. That's true.
Ms. Hilsenrath goes on to say that the spike appears to have levelled off in subsequent years and should be read within the context of an increase already prevalent not only in mental health cases but across the gamut of complaints about the health service,
Yeah.
which is not attributable to the pandemic. So I understand it as saying that there's a general overall increase,
Yeah.
even if one puts the pandemic to one side. Would you agree with that?
I would, yes.
What is, in your opinion, is the main reason, or are the main reasons for this overall rise in health and mental health related complaints?
Because the National Health Service has been under increasing pressure in terms of finance, in terms of staff, in terms of the morale of the staff, in terms of the reliance on bank temporary staff to cover. And it's very interesting to me that the National Audit Office found a couple of years ago that 30% of people who leave the National Health Service as either nurses or staff say that it's stress and mental health challenges that have caused them to do this. And I think we need to be very careful about stigmatizing the generality of staff in the health service without recognizing the great challenges that they've had to put up with. So one of the things that I tried to do as Ombudsman was to go around as many health service establishments as I could to meet with those who worked in the situations, to meet with patients. And going to mental health units was very challenging for me, and I was just there as a visitor. So I don't underestimate what it takes to work in these situations, and that to me would be one of the reasons why there's a rise in complaints. And the other reason which is tragic but very important, is that there is a decline of public trust in the health service, which used to be the exception to the general decline in public trust in public services. That is no longer the case.
Can we look, staying with this chart, at the information relating to Essex specifically? So that's the light blue bar. We can see there, I think, figures fluctuating from the low 70s and going up to the mid 120s concerning complaints relating to Essex trusts. And in fact, you observe in your second statement that cases related to Essex were on average 5% of the cases related to mental health over this period. Is there any significance in that level of Essex complaints as opposed to the national picture that you can think of?
I honestly don't think so. I've tried to think of whether or not there is, but I can't see that from the figures.
Thank you. Could you take down the chart, please? You refer in your second statement at paragraph 10, for those who are following, to themes arising from the complaints the PHSA received about Essex trusts. And I'd like to just look at those themes now. The first of the themes that you identify is discharge, or poor discharge planning. Is discharge. Could you just expand a little on what that theme encompasses?
Could you just point me to the...
Yes, it's page 7 of your second statement at paragraph 10.1. We could put it up on the screen.
Yes, please, if you would.
Could you put up, and this hasn't been notified, but could you put up core bundle, page 246, please? And could you expand paragraph 10 up to the end of 10.2, please? So here you've been asked to confirm matters about Essex, and we can see at 10.2, complaints received about Essex Trust, discharge is a relatively common theme. And I've just asked you to expand on what you meant in an Essex context about the discharge theme.
Yes, thank you. I mean, I need to be careful about generalising, but as far as I can recall, in the Essex situation, but it's not confined to Essex, there was a lack of consideration of the personal circumstances people were in when they were discharged, a failure to listen to the families and to the patients about what would be appropriate for them, and priority given to the convenience of the trusts and the bodies in jurisdiction about how people should be discharged. There was therefore a routinisation and a lack of empathy in dealing with that issue, which I think is not just confined to Essex.
The routinisation or the lack of empathy is something that the inquiry is interested in. Do you, I mean, you've already mentioned the difficult circumstances, particularly in mental health units that you visited, but do you have a view as to why that came about or when that came about?
Well, I think, in my experience, it was always there from the moment that I became the Ombudsman. And, you know, I have great appreciation for the work that people, clinicians in the health service do, and managers too. But there are two things that I recall. One is that if I would go to a hospital, the chair and the chief executive would welcome me and say, "Thank you for coming, we're all in this together, and we're one big happy family." And as soon as you left them and went round the trust, and met individual clinicians, you saw that that was not necessarily the case.
Can we be clear? Are you talking about the situation nationally or in a general way, or are you talking specifically about the experience in Essex?
No, I'm talking about the general situation. And that was always the issue, that people were working under very great stress, and they felt, when they talked to me, that they didn't have the necessary development, training and profile to be able to address the issues that they were dealing with as appropriately as they might.
Thank you. Amanda, would you expand now 10.3 and 10.4? This is now returning to the themes arising from Essex. Oh, I'm sorry. In fact, I can see there are two 10.3s. Would you expand the paragraph that's at the top, the one above that, please? You'll see that there are two 10.3s. Thank you. So another theme is you talk about here is poor communication.
Yes, I mean, I don't want to labour the point, but in the cases that I looked at in Essex, including the missed opportunities one, what stands out is the scant communication between the patient and the clinician, which was disastrous for the safety of the patient. And, you know, even when it's not disastrous for the safety of the patient, it is a feature of the NHS more widely.
And you've spoken already of a failure to listen.
Yeah, I mean, when we came on to missed opportunities, in both of the cases there was a cavalier approach to communication, which was disastrous for the survival of the two people involved.
And then we can see the last of the issues that you refer to is poor record keeping.
Yeah.
And again, is that an issue that you see more widely, not beyond Essex?
Absolutely. I mean, as I said, I was higher education ombudsman, I was ombudsman in legal services. I did not expect the fabrication of documents to feature in my role as health service ombudsman, and it has done. And the failure to record what has happened, both in Essex and outside Essex, has been shocking.
Is shocking a word that you use regularly in relation to your work, or does this really stand out?
I try not to be sensationalist, but I think it's an appropriate term to use.
And do we see that the Essex issues we've just been looking at reflect, to at least a certain extent, those five key issues that you identified in maintaining momentum?
They do.
Could you take that down, please? And I'd like to move on now, please, Sir Rob, to missed opportunities and to the tragic cases of Mr. R and Matthew Leahy.
Before you go on, you just said how shocking the communication, the record-keeping falsification was for you. Have you encountered it elsewhere other than Essex?
Yes. In a number of cases, in Bristol, in the Robbie Powell case, untruths were written down for the convenience and the reputation of the body in jurisdiction rather than accurately describing what had happened to the patient.
Chair,
Document in the Powell case, documents went missing. They disappeared, and that was brought to the attention of the Crown Prosecution Service, but nothing came of that.
well, we may be looking in a moment at some similar issues in the missed opportunities report.
Yeah.
Chair, as I've mentioned, I'm coming on now to talk about and ask Sir Rob about missed opportunities. And this report includes some very difficult details. And I just want to give a warning again to people about that so that they're prepared. And I refer everyone back to what I said at the start of this hearing about the availability of support, being able to leave the room at any time if you want to, and so on. So, Rob, you refer in your first statement about when the Ombudsman would become personally responsible in investigations. I could take you to the paragraph if we need to, but when would that in general be?
There is a body that the Ombudsman chairs, which on a monthly basis looks at high-profile, complex cases, and decisions are made collectively within the office about who, in a very senior position, would take responsibility for the oversight of those cases. So pretty soon after something comes in and it's agreed that it's an issue to look at, a decision will be made about who will take responsibility for it. It might be the Ombudsman, it might be one of the two deputy Ombudsman leaders, or it might be someone else in a senior position.
And what would if say you became involved in a case, what would the nature of your involvement be?
Well, I would be the strategic leader of the investigation. So there would be a case handler or case handlers, a team of people. There would be an operations manager. There would be other people involved. But they would meet with me as Ombudsman to give me an update about what was happening, what needed to be done, and where, what should our position be on various issues. And I would be familiar with the case, and in certain circumstances I would meet with the families involved.
Now we're going to hear that you took on that role in relation to Matthew Leahy's investigation once you'd become Ombudsman. I believe that investigation started before you took up your post. Was the process that you've just described the process by which you decided to become personally involved in that case?
I created the high-risk committee, but there was an informal way of doing it. And it became very evident very early on that the Ombudsman should take responsibility for this case.
And is that for the issues that we're about to come on and discuss?
And just, I need to put on record that I had the privilege of meeting Mrs. Leahy on a number of occasions, and she was an exemplary complainant. She had her own views. She was very well prepared for every meeting. She was courteous but assertive. She knew what she wanted out of an investigation. And given the tragedy that she'd been through, it was a remarkable contribution to public life that she performed over many years. And that needs to go on the record.
And I may ask you about another aspect or aspects of Melanie Leahy's involvement in a moment. But what I'd like to do is to start with the case of the person we're calling Mr. R.
Yeah.
He died in December 2008, and the complaint, we understand, was brought to the PHSO in October 2015. And the case closed in February 2017. So these are dates as I understand it, before you became Ombudsman. Can I just ask you one question that we see here, but we see it elsewhere as well? We've got a complaint brought in 2015 that is then closed in 2017. Is that kind of delay normal? Is there any usual amount of time it takes between a complaint being accepted and the case being closed?
It's a good question. I think that these are very sensitive cases. They will be prolonged if new evidence becomes available during the course of the investigation, or if the family or the body in jurisdiction brings it forward. There are always delays in waiting to receive information from the body in jurisdiction. As an intimate part and parcel of both these cases, there was clinical evidence which we commissioned from independent practitioners, which takes a long time to gather together and then to review. So with such serious cases, we don't want to make mistakes, and perhaps they take too long, but that is because even when you get to the end, people may say, I don't think you've got it right, and these are the reasons for it, so we would go back and have a look at it. I will say one of the things that is not often mentioned is, of course, the trauma and the tragedy lies with the families of the complainants, but the stress and the trauma of the case handlers looking at an issue over between 2 and 5 years is very great indeed. And I personally know the people who were involved in these cases, and it took a great deal out of them because of the very sensitive issues that they had to deal with in a professional way.
Well, we're going to come on and look at some of those issues in a moment. What I'd like to do is, obviously, missed opportunities includes Mr. R as one of the two cases. And what I'd like to do is, with you, to look at what the report says about Mr. R and the issues arising from his very tragic death. Could we please put up Exhibits Bundle, page 191, please? So this is just the front cover of the report. We've talked about it already several times. Was the report published in June 2019?
Yes.
Could you please now, Amanda, go to page 206 and put up the whole page? Can we see here the start of the report addressing of Mr. R's case? And do we see here that at age 20, Mr. R was admitted to NEP on the 8th of December 2008 to the Linden Centre as an informal patient? And I'm not going to read all of this, but I do want to read parts of it. And if we drop down in the left-hand column, we can see on the evening of the 28th of December, Mr. R asked to be discharged. A short time later, he was found in an unresponsive state in his room. Attempts to resuscitate him were unsuccessful. After Mr. R's death, the Trust prepared a 7-day report, followed by a serious incident panel inquiry, which was completed in July 2009. An inquest into Mr. R's death in February 2011 recorded a narrative conclusion. Mr. R killed himself while the balance of his mind was disturbed, before his illness was fully diagnosed, to ensure a suitable care programme to be implemented to manage his condition. These factors more than minimally contributed to his death. And do you then, having summarised matters in that way, set out what the PHSO found in his case? And can we see at the top right-hand corner of the page, we found failings in the care and treatment provided to Mr. R, which meant there were missed opportunities to mitigate the risk of him taking his own life. Miss R, his mother, suffers the ongoing injustice of knowing this and also knowing that he did not receive the standard of care he should have done. And does the report then set out areas or failings that you had identified? And can we see failings in relation to medication, to ward leave, in that NEP failed to manage Mr. R's ward leave in line with its policy, in relation to physical restraint, in relation to care and treatment on the 28th of December 2008, and it says there that Mr. R's initial care plan had not been updated and the assessment and management of risk was not adequate. Mr. R had been admitted at, and would you go to the next page, please? Risk of suicide, but there was no mitigation plan in place other than as needed lorazepam. NEP acknowledged through its own investigation that staff had not responded adequately when Mr. R threatened to harm himself on the 28th of December. Environmental risks were also not properly managed. An assessment in 2007 rated certain ligature points as low risk. Before Mr. R's death, these environmental risks had changed but had not been identified or acted upon. Thank you. Could you take that down? As we established, this is an investigation that was conducted before you became Ombudsman, but do you have any observations on the points that we've just looked at in the report there?
Yes, I think time and again there were assumptions made and a failure to follow up, which were seriously problematic for the patient. And in every aspect of his care, he didn't receive the detailed attention that he was entitled to, which contributed to the way in which he finally died. And it's you know, in hindsight, the treatment that he was given was not checked. The implications of what the treatment, what impact it had on him, weren't looked at. The ward leave was granted at the same time as his dosages were increased. And staff behaved improperly when it came to physically restraining him. He deserved much better. And one of the things I'd like to say this is that some clinicians were interviewed after he died, and they had a very patronising approach to him, saying that in their view he didn't have mental health problems at all, and that he had been admitted because he wanted somewhere to live, because he was homeless. I mean, that is staggering.
Thank you. What I'd like to do now is come on to the case of Matthew Leahy. As you've explained in your statement, Melanie Leahy brought her complaint about Matthew's care to the PHSO in March 2015. This is paragraph 63 of your statement. And you then explain how the complaint was proceeded with. The investigation was commenced in June 2015. The scope of the investigation was subsequently extended twice, and the case ultimately closed in June 2019. So we can see that this was an investigation that was over 4 years in duration. And as you've said, you oversaw this complaint, and as you've explained, you were looking at the strategic direction of the complaint. Is that correct?
Yes.
As we've seen, or as I've just mentioned, the scope of the investigation was extended twice. It was one of the reasons that it was extended because Melanie Leahy had herself provided further information
Yes.
to you. Was she persistent in the way that she assisted with the investigation of her complaint?
Lord Scarman once used the word persistent in a not very nice way to describe the behaviour of the Metropolitan Police. Mrs. Leahy was persistent in the best possible sense of the term, that she was better informed than almost anybody else about the case. She was willing to put the information in the public domain, and she articulated her views with precision and forcefulness. She was the model interlocutor in a case like this.
Well, as we'll come on to see very shortly, there was a high number of findings of maladministration in Matthew's case.
Yes.
Did that in part reflect Melanie Leahy's input and the information that she provided?
Absolutely. I mean, without her, this case might have gone away, not only at the Ombudsman, but after the Ombudsman. And one of the issues for all of us is why it has taken so long for this finally to become a matter of public importance in the way that it is.
I'd like now to look at missed opportunities where the report addresses Matthew's case. And can we do this in the same way that we did with Mr. R? Could you put up, please, page 208 of the exhibits bundle? And the whole page, please. So we see that Matthew was 20, and on the 7th of November 2012, police brought Matthew to the Linden Centre as a place of safety. On the 8th of November, he told staff he'd hang himself if they gave him injectable medication. On the 9th of November, he alleged he'd been raped during the night. On the 15th of November, staff found him hanging in his room. After attempts to resuscitate him, he was taken to A&E at Broomfield Hospital, where he died. A number of investigations have been carried out, it says here in the report, into Matthew's death and the alleged failings in his care and treatment. In January 2013, NEP completed a serious incident panel investigation that concluded care and treatment was of a good standard. And in January 2015, the report continues, an inquest was held that considered a report from an independent psychiatrist which concluded that overall, NEP had provided an acceptable level of care. And a police report commenting on the independent psychiatrist's findings said Matthew's care was appropriate at the time of his death. However, as we can see at the bottom of the page, a report by a second independent psychiatrist said the treatment provided to Matthew fell below the standard of a reasonably competent practitioner, and the inquest recorded a narrative conclusion which said Matthew was subject to a series of multiple failings and missed opportunities over a prolonged period of time by those entrusted with his care. So we see the word missed opportunities used both in the report as it related to Mr. R and here as it related to Matthew's case. And is that why you gave the report that name?
Yeah.
And in the same way as you did, or the report did, in relation to Mr. R, have you in the report also set out a summary of what you found?
Yes.
And we can see here it says we found that some aspects of Matthew's care and treatment were in line with relevant guidelines, but our investigation also identified a number of significant failings in key elements of care. Knowing Matthew did not receive adequate care has caused unimaginable distress to his family. We also found that NEP's investigations were not robust enough and that NEP was not open and honest with his family about the steps being taken to improve safety at the Linden Centre. When his family came to us, NEP had not taken sufficient and timely action to put things right. This added to the distress and frustration as there was no reassurance that things had changed for the better. And do you then set out various failings, or a large number of failings, that the PHSO concluded had been the case with Matthew?
There were 19 instances of maladministration which we identified.
And is that level or that number of incidents of maladministration unusual?
It is unusual.
And is it unusual because of the number?
Well, not only the number, but the seriousness of the failures.
Can we look at them? So we could see a failing in relation to care planning, or failures in relation to care planning, in that NEP did not ensure Matthew's care was adequately planned. And could you go to the next page, please, and expand the whole page? Thank you. And we can see that there were issues in relation to risk assessment and management. The assessment and management of risk during Matthew's admission was not rigorous enough. And in relation to his physical health and nutrition, in that NEP did not take adequate care of Matthew's physical health. Again, in relation to medication, and in relation to observation and engagement, Matthew's observations were not properly managed. And we heard that there'd been a rape allegation and a failure in response to that allegation, in that staff did not take adequate action when Matthew reported being raped on the 9th of November. And could you go to the next full page, please? Again, continuing with the areas of failure, allocation of a key worker, and that NEP failed to properly allocate one to Matthew. Record keeping, which is a point that you've already referred to. Here, specifically in relation to Matthew's case, NEP's record keeping was not always as robust as it should have been. Some paperwork was lost, and Matthew's care plan was falsified. And then NEP's investigations, looking at the first paragraph there, overall, the investigations into Matthew's death were not adequate. NEP's 7-day report contains inaccurate information about how Matthew's care plan was reviewed. It lacks credibility because it was written by a member of staff who was later found to have been involved in the falsification of Matthew's care plan. And then we can see also failures in relation to a lack of timely safety improvements. After Matthew's death, NEP reviewed some of its policies and practices, but did not make substantive physical improvements in the Linden Centre until August 2015. Could you take that down, please? What was your personal response to the findings in the case of Matthew's investigation, as including, as we've just seen, summarised in missed opportunities?
Well, first of all, it was a combination of the service failure and then the refusal in the serious incidents report to accept that there were issues to address, which were entirely inappropriate. Interestingly, the person who falsified the accounts, the care plan, was referred to the NMC, but did not lose their ability to work in the health service afterwards, which I think is inappropriate. And I did an interview for ITV News, and afterwards the newscaster said, "You're very angry, aren't you?" I don't see that very often in public servants. And I was a bit ashamed at the time that I showed that anger. But actually, reflecting on it, this was a disgrace. This was the National Health Service at its worst and needed calling out.
You say this in your statement. I can read it out, and if you want me to, I can get it put up on the screen. But there was, in summary, a near complete failure of the leadership of this trust, certainly before it was merged. This was an indictment of the health service.
Yeah. And I don't say that lightly.
And
As
you
I
say,
we do have to accept that leaders operate in very difficult conditions and situations, but this was entirely unacceptable.
and in missed opportunities, the report includes this. Again, we can go to it if we need to, but that the issues uncovered demonstrated wider systemic issues at the Trust, including a failure over many years to develop the learning culture necessary to prevent similar mistakes from being repeated. Could you expand on that?
Well, I mean, this is a structural challenge for the NHS broadly, which it still hasn't yet got to grips with, and that is to put patient safety issues above the reputation of the institution that leaders work at. And time and again, I've seen that to be the case. It's still the case as far as I can see, and in this case it was absolutely clear that there was a failure of leadership, a failure to understand the importance of cultural appropriateness in organisations which treat people with dignity.
You refer in your statement to the different accounts given by Trust staff about what had happened in the last couple of hours before Matthew was found in his room. And you say this: none of the parties had a shared view of Matthew Leahy's behaviour and who'd said what to whom. Therefore, even on the balance of probabilities, we were unable to make a decision about what really happened, which we know was very difficult for Matthew Leahy's family. That does lead to the question about the PHSO approach generally, where there's more than one version of events. First of all, who within the PHSO makes a decision on the basis of conflicting facts?
I mean, that is, if you have a team of people under the Ombudsman looking at cases, then that will be discussed before a report is concluded. So it wouldn't be just one case handler coming to that view. I can remember it was discussed.
You refer in your statement there to establishing things even on the balance of probabilities. Is that the standard of proof that you'd apply where there were factual disputes?
Yes.
Why did differing accounts cause you to be unable to come to a view on the balance of probabilities? For example, do you normally require a consensus before coming to a view?
I think we do have to make judgments, and but we're not a court, and we don't have an adversarial approach to weighing the evidence, and that was the view which was arrived at. Whether it was the correct one or not, I don't know. But it didn't take away from the complete failure of the Trust to deal with Matthew's care.
Would you adopt a different approach to that factual dispute now?
I'm no longer the Ombudsman.
And do PHSO procedures allow a complainant to challenge a decision that's been made about a factual dispute?
They can say, you've got the facts wrong.
And what would happen after that?
That would be reviewed.
Do you know if that happened in relation to Matthew's case?
I can't remember, but I know Mrs. Leahy was not happy with that particular aspect of the findings, and I have respect for her view.
I want to move on now, before lunch, to the recommendations that the PHSO made in relation to Matthew's investigation. So this is not missed opportunities, this is the actual investigation itself. And you describe in your statement, this is paragraph 70, how the PHSO, following that investigation, went on to make a series of recommendations. And just summarising, did these recommendations include writing to Melanie Leahy to provide a full and final acknowledgement of the failings identified in the report of her complaint and the distress that this had caused her? An apology and £500 payment for distress caused by NEP's incorrect information about the extent of safety changes it had made,
Yeah.
and writing to Melanie Leahy to provide a detailed summary of the action that had or would be taken to help prevent a recurrence of the failings identified. And did the PHSO add both that copies of the information should be provided to the PHSO itself, and that a copy of the investigation report and information should also be sent to the CQC?
Yes.
Did EPUT accept the recommendations when they were sent to them? Did you hear that?
No.
Did EPUT accept the recommendations when they were sent to them?
Yes.
And this is dealt with in your second statement at paragraph 8.3, but on what basis are you able to say that that EPUT implemented the recommendations that were contained within the report?
I can't remember it precisely, but what I do know is that the situation was changed by the merger of the trust, and that the new leadership which came in had a slightly more enlightened approach to the issues that were addressed. And when CQC did a follow-up investigation, they noted that.
Well, just dealing with that very briefly, if I may. Clearly, you may be referring to a specific CQC investigation. Can I just make sure you can hear my
Yeah.
questions here? You may be referring there to a specific CQC investigation. Clearly, this inquiry will need to have regard to all relevant CQC investigations within the period that we're concerned
Yeah.
with. You say in your statement, just in relation to the recommendations that were sent to EPUT in relation to Matthew Leahy, that you were able to check that an apology had been sent and that there'd been evidence of the financial remedy and of an action plan and policies, and that a caseworker requested clinical advice to assess compliance, and that compliance was closed in October 2019. Were you aware that Melanie Leahy gave written evidence to PACAC, the Public Administration and Constitutional Affairs Committee, which included that the action plan provided by EPUT in relation to the PHSO report findings does, and using her words, does not give me confidence in the timeliness or robustness of their approach to addressing their failures?
Yes.
Chair, we are now just at lunchtime. I don't have a huge amount more to ask Sir Rob about, but I think this would be a convenient moment to rise.
When would you like us to come back again?
Could we come back again at 2 o'clock, please?